Well, hello everyone. I want to welcome you all to this wonderful CLE presentation sponsored by the Leafer Border Justice Initiative. My name is Patrick Lopez. I'm the Associate Director of Career Services at UNM Law School. And with us today, we are very pleased to welcome Jessica Miles, who will be running this presentation. I do want to talk about a couple of housekeeping matters. Each of you should have received a CLE form. If you would like to receive CLE credit for this presentation, you simply fill out the form, follow the steps, and email it back to Sue George, I believe it is. And we will be recording this presentation, just so you're all aware. So you are welcome to keep your screens on or off as you prefer. I will be monitoring the chat as well as some other people that are working with us. So if you have any questions, chat is probably the best way to submit them, and we will do our best to have Jessica's opinion and insight onto those questions. Jessica Miles has been working with the Leafer Border Justice Initiative, and she is a fantastic, fabulous, qualified immigration lawyer. She works in El Paso near the border. She has worked with many NGOs and nonprofits on human rights issues and immigration issues. She's co-founder of the Borderland Immigration Council, and she's a member of our management team here with the Leafer Border Justice Initiative. In 2019, she opened her own practice, Miles Immigration Law, to focus on asylum clients and families that are in need of immigration services. She brings a breadth of experience and knowledge to the table, and she has an excellent presentation planned for us today, which I am very excited about. With that in mind, I will turn the time over to Jessie, and we will be available for questions. Before we proceed, also, if anyone is interested in getting involved in border justice issues, I will post my email address in the chat, and you can contact me if you're interested in finding out more, finding out how you can get involved. And again, thank you so much, and I'll turn the time over to Jessie.
Hi, everybody. My name is Jessica Miles. Like Patrick said, I am a private immigration lawyer in El Paso. I graduated from UNM School of Law, and I still work a lot with the Law Office of the Public Defender in New Mexico to provide immigration advice for indigent defendants. If you have used that option with the LOPD before, you probably have a memo with my name on it and my email address. If you have not used it before, or you don't know that that was an option, I would encourage you to email me, and I can provide you with some information about how to request help in advising immigration clients. But today I wanted to talk about DWI because it's one of the most common questions or common types of immigration advice that I have requested through that contract, and generally from my colleagues who do criminal law. And it's funny because when I first started doing the contract several years ago, it was like the most simple type of advice to provide. But now, as we'll see, things have really changed in terms of how DWI is treated by federal officials in the context of immigration law. So hopefully we can go through some of that today. Let's see. The goals for this section are, number one, to orient ourselves towards the immigration reality, fears, and consequences that criminal defendants face. And for that, I'm going to be asking you all to kind of throw out some of those fears or some of those questions that you hear from your clients. So get ready, please, to provide that feedback. Second, we're going to talk about how DWI has really been weaponized in the past few years, really starting under the Obama administration, to increase the amount of people who are eligible for removal or who will be prioritized for removal. And then finally, I want to discuss how to advise clients accurately regarding DWI. And there will be a more thorough CLE, a two-part CLE actually, coming up in the same series, and it's worth 2 ethics credits. So I suggest that you all sign up for that one as well. So to start, let's talk about the fears that clients have when they're facing a DWI and they don't have status. what are some of the questions that you guys are getting, or what are some of the fears that clients are communicating to you? And just mute yourself and shout them out, and I'll take notes here.
They're worried about being removed.
Yep.
They're worried
Yes.
about ICE picking them up when they show up to their court hearing.
And they're worried about probation, reporting them to ICE if they have to do probation.
They're worried about DACA being revoked.
Anything else?
They're worried about how DWIs affect discretion in adjustments. And I suppose in DACA, just discretion in general.
See if I can learn who's still here. Anything else folks want to add?
There's a comment on chat not being eligible for U visas or VAWA.
I'm going to try to keep some of these questions in mind while I'm going through, because some of these questions I'm not addressing, or I don't have slides that particularly address these specific questions. So I'm going to try to address them as we go. But if you notice that I haven't addressed it and it seems like a good time to bring it up, please put it in the chat, and then Patrick will remind me and we'll answer some of these questions. Okay. Yeah, I think, let's see. One moment. Ooh, it's hard to change the slide with that. There we go. So yeah, I think that that those are all questions and fears that clients have. I think the number one thing that I hear is, am I going to be deported? Right? And that question really depends on a variety of factors. But the reality is that for some, if not many of our clients, that removal proceedings is what they are going to be going into, right? Regardless of what you do with the DWI, because maybe they're undocumented, or maybe they have another criminal conviction that subjects them to removal proceedings. So I wanted to take a minute just to review how removal proceedings work. I know a lot of you already know this, but I think it's good to refresh. So if they are detained or released from state or federal custody, generally they may be picked up by ICE either right when they get released by the state officials. I know that in some jurisdictions they're still honoring the 48-hour holds, and in some they are not. So in places like Santa Fe, for example, the person may not be picked up by ICE when they are released from jail, but they may get picked up later, right, by probation, when they go to their probation appointment, or even when they're just at their home. And so I think it's important to always advise clients of the risk of being picked up by ICE. If they are picked up by ICE, then, and subject to removal, they'll be issued what's called a notice to appear, which is our version of the complaint that you would see in a criminal case. That contains the charges against the client and the grounds for which the government is trying to order them deported. Within the context of immigration proceedings, they'll also be, in some cases, eligible to request a bond. It's important for clients to know that bond proceedings are not automatic like they are in the criminal, on the criminal side, which means that not only is bond not a guarantee, but also even to get a bond hearing, you have to make a written or an oral request for a bond proceeding. It doesn't just happen. And in fact, judges won't even bring it up unless the client or their attorney specifically asks for a bond hearing. Additionally, not everyone is going to be eligible for bond. And that will really depend on the way that they came into the United States, but also, and more significantly, their criminal history. If they're released on a bond, they can continue with their removal proceedings outside of the detention center, what are called non-detained removal proceedings. And for folks that are in New Mexico all of those detained removal proceedings are going to occur in El Paso, in downtown El Paso. That's where the non-detained court is. There have been discussions about potentially opening a detained court in Albuquerque, and that was a discussion that occurred under the Obama administration, and then it never quite got any legs. So who knows, we may have a detained court eventually in Albuquerque, but for right now, everything in New Mexico is going to go to El Paso. If they're not able to get a bond, then they have to continue their removal proceedings in detained court. For New Mexico folks, there are 2 different detention centers that have courts. One is in El Paso, and the other is in Otero County, which is near Chaparral, New Mexico, which is about 30 minutes outside of El Paso, but is technically in New Mexico. And both of those courts have judges that adjudicate removal proceedings. The detained removal proceeding, that is kind of an expedited proceeding. And you can expect a client to go through at least the initial phase of that proceeding within 3 to 6 months, possibly, not including any sort of appeals. Whereas non-detained removal proceedings take several years. And so the impact on a client is huge, particularly if their eligibility for relief is not very strong. And getting them out on a bond could literally be the difference between them being able to remain in the States for several more years to provide for their family or being swiftly deported. And then within the context of removal proceedings, whether they're detained or non-detained, clients are allowed to apply for immigration relief. And there are several different types of relief that folks can apply for. And we'll go over several of those types. So this is the reality, right? This is how removal proceedings generally go. So let's talk about what our duty is to advise. And like I said, it's going to be a 2-part CLE on duty to advise on December 4th and December 11th, but we'll talk about it a little bit here. So within the scope of state law, New Mexico state law, not federal duty to advise, can folks tell me at what parts of this process do we have a duty to advise clients about the consequences of their criminal convictions?
I would say at arraignment, if you're going to ask when you're advising your clients on the charge and you're getting their information, I like to know, and our office likes to know what their immigration status is and things like that. So that way we can kind of prep them for everything that's, that may unfold.
So you're kind of starting to gather that information at arraignment that you'll need to advise them? Okay. And in terms of this process and how criminal convictions can affect people, what do folks think are the areas that criminal convictions can affect clients in this kind of process? Maybe I've asked the question in a let me backtrack. When we're advising our clients on the consequences of a criminal offense, what are the 3 or 4 things that we need to advise them about?
So you want, they need to know what they're being charged with, what the potential penalties for that charge are, and the collateral consequences.
Right. Yeah, exactly. So in terms of collateral consequences, and this is why this great CLE will happen on the 4th, what you have a duty to advise, and I say you, I mean we, what we have a duty to advise our clients about is not just whether they're going to be put into deportation proceedings, right? That's one thing. We have to advise them whether or not they will be issued a notice to appear, whether or not they will be placed into deportation proceedings to possible removal, right? That's the Paredes case that talks about virtual certainty of deportation. That was kind of the beginning of the duty to advise standards in New Mexico. But additionally, under Paredes, we also have to advise about whether or not the criminal conviction is going to affect their eligibility for bond. That is an absolute must, and we'll talk about that in a moment. Third, we have to also advise whether a criminal conviction is going to affect the client's ability to qualify for relief. Okay. And as I said, there's lots of types of relief, and we're going to talk about those within the context of DWI today. But even beyond all of these things, which is a lot, right? It's more than the federal standard. We also have to advise on a fourth thing, which is whether or not a criminal conviction will affect their eligibility for future or collateral immigration benefits. This includes everything that is outside of the scope of removal proceedings, such as coming to the United States in the future, qualifying for an immigrant visa through a family member in the future, qualifying for a U visa, a T visa, or a humanitarian visa, which is not within the context of removal proceedings. The scope of advice that criminal defense attorneys have to provide in New Mexico is very broad. And that's a good thing. It's very onerous, for sure. It's difficult to meet the standards sometimes, but it's really important because a small criminal conviction, such as a misdemeanor possession of drug paraphernalia, for example, it can ruin someone's life. So on the criminal side, maybe they just get, a slap on the wrist and some probation, but on the immigration side, it can have a detrimental effect to an immigrant's life for the rest of their life. So this is a really important scope of advice that we have to provide. And luckily, through the Office of the Public Defender, you all have access to immigration attorneys to provide this advice or to help you to provide this advice. And so please take advantage of that. These are all the things we have to advise. The first thing I want to get out of the way is the kind of most straightforward part of the analysis for DWI. And that is a DWI a crime involving moral turpitude? Many of us know crime involving moral turpitude, or as we call CIMTs, those are bad for everybody. They're bad in different ways depending on their status and things like that, but they're bad for everybody. So you want to avoid them like the plague. So is DWI a crime involving moral turpitude? Nope. Generally, nope. This is the citation to the BIA case that discusses that. And the reason is that DWI generally does not require intentional conduct, and it does not require any sort of malice to commit a DWI, right? All you have to do to have a DWI is be driving, or sometimes not even driving, right? And you've got to be above a legal limit or substantially impaired in driving. And so it kind of operates like a strict liability offense, and in immigration law, strict liability offenses are not considered to be CIMTs. Now, there is an exception, and that is where an aggravated DWI has as an aggravating factor something that has an element of knowledge or intentional conduct. And so one example in California is they have aggravated DWI, and one of the aggravating factors is if you get a DWI while your license is suspended for having a DWI. And the thinking goes that you had knowledge that your license was suspended and you drove anyway. And that's what qualifies it as a CIMT. In New Mexico, we don't have an aggravating factor like that. The three aggravating factors that we have are twice the legal limit, bodily injury, and refusing to submit to the testing, right? None of those require intentional conduct. And so none of those appear to make an aggravated DWI a CIMT. One caveat I will say is that the second one really makes me nervous, okay, because it does cause bodily harm. There's no case law that's directly on point on this statute, on this subsection, but I generally advise folks to, if they are going to plead somebody to the aggravated DWI, that you make it clear in the plea and in the judgment that they're pleading to subsection 1 or subsection 3, because those are very clearly not CIMTs. If your client is pleading to an aggravated DWI based on the facts that they cause bodily injury, then I would try to be as general as you can in the plea and disposition agreement, pleading only to like the general subsection, right, 66.8.102D, and not specify that it's the subsection 2, and then leave out any sort of facts that discuss the bodily injury, or if you have facts that support subsection 1 or subsection 3. See if you can to allow you to plead to one of those subsections instead. So are there any questions about this part before we move on to kind of some more complicated things? Okay. Patrick, let me know if we get any questions on that.
We did have one comment in chat, but I think we're covering it right now. The effects of DWI on good moral character requirements.
We are going to get to the GMC stuff, so
Okay.
don't worry. Okay. This statute, this new statute has been the bane of my research existence since it was passed and we started charging people with it. It's driving the new misdemeanor conviction of driving while intoxicated with a minor in the vehicle. The question is this the CIMT? The answer is nobody knows yet. Okay, it's brand new. There's no case law on it. And if we look to other statutes in other states that are similar, there's one in California, there's one in Texas. Nobody really seems to be in agreement there either. And the reason that we don't have any kind of solid case law on this issue is because generally these types of crimes are misdemeanors. And misdemeanor CIMTs, they can and they do affect people, but not often. So the likelihood that those are going to go up on an appeal so that we can get some good case law and decisions on this are very rare. So we have to look at this statute based on the elements and what we know constitutes a CIMT. And so to do that, we kind of weigh what's in it. On the one hand, there's no intentional conduct involved, right? This is still a liability offense, no maliciousness, and there's no requirement for bodily harm. Which, you know, within other contexts, like assault and battery, a requirement of bodily harm can elevate something to constitute a CIMT. So it looks like it's not one. On the other hand, it's a kid, right? And we worry about children, we worry about child endangerment. Now, this statute doesn't require that the child is endangered. Maybe there's an argument that there's some intrinsic endangerment when you put a kid in a car with somebody who's driving while intoxicated, but you know, there's nothing explicit. The problem is that CIMTs are tricky and they're subject to change based on the case law that comes after these statutes are starting to be applied. And so for the time being, if you cannot plead your client to this, I think that's the safest thing to do. If you have to plead your client to this because, you know, the state's not budging, it looks like this is the best option, a couple of things to keep in mind. Number one, it is a misdemeanor. Now, like I said, that doesn't mean that it isn't going to affect your client because there is a petty offense exception to CIMTs. And what that means is that basically you get one misdemeanor conviction for a CIMT so long as the penalty imposed is 180 days or less of a sentence of incarceration. Okay, you get one of those. So if you are going to plead your client to this, make sure they don't have any other CIMT misdemeanor convictions, right? Because 2 makes you deportable. And you need to advise them that they can't get any more convictions like this. Because again, once they get 2 misdemeanor CIMT convictions, then it becomes a big problem for them. But if you can, try not to plead your client to this until we know a little bit more about it. Questions about that? Okay. Let's talk about the other ways that DWI can affect people. So being a CIMT isn't the only way that your client can be affected. Driving while intoxicated has really been weaponized by different administrations in the last 10 years or so. And really, in my view, started in 2014 under the Obama administration. What happened is that in creating DACA, right, Deferred Action for Childhood Arrivals, which provides some protection for people who are brought here as children, DWI was defined as what's called a significant misdemeanor. And a significant misdemeanor conviction for a significant misdemeanor is a bar to DACA and can result in the revocation of a DACA status. In addition, the enforcement priorities under the Obama administration made it clear that people who had one conviction for a DWI would be prioritized for deportation. And so I know it seems like such a long time now that we made intelligent, I think, choices about who we try to deport and who we don't. But under the Obama enforcement priority memo, the 2014 memo, basically the administration said, we don't have the resources and the time to deport every single person in the United States who's subject to deportation or who is undocumented. And it would be completely inhumane for us to do that. So instead, we're going to delineate the classes of undocumented people that we are going to move forward to try to deport. And within that were people who had convictions for DWI. This theme continued when they created DAPA, which was the program that was supposed to protect the parents of DACA folks. I think, I hope that this isn't the case, but I wonder and worry if any of the changes that will be made under the Biden administration will continue to classify DWI as a significant misdemeanor and will affect people. So that's something to keep in mind. This got incredibly worse under the Trump administration, as you may suspect. So in terms of custody proceedings, I think it's always difficult to get a bond when you have a bunch of DWIs. When you had one DWI, it could still be difficult to get a bond within the context of immigration proceedings. But in 2018, it became more difficult because there was a case that instructed judges to include DWI as a significant adverse factor against bond. So it's going to affect your client's ability to get out on a bond. Additionally, in 2019, the Attorney General decided that 2 or more DWIs would be presumptive evidence of a lack of good moral character. And we're going to talk about how that affects us in the real world, but it's important to know that that 2 or more DWIs are a problem. And recently, although I hope that this rule does not go into effect, there was a proposed rule by the Trump administration that would bar asylum completely to anybody who had a DWI conviction, which completely blows my mind. But it is a proposed rule, and if it is allowed to go into effect, it will have significant effects on people's ability to gain asylum protections. It also would deny asylum to anybody with any felony conviction. And there's other examples here. So when we analyze immigration consequences, and I asked my husband about this. My husband is a public defender here in El Paso. And I asked him, as an immigration or as a criminal defense attorney, you know, what would you want to know about DWI and immigration consequences? And he said, well, I want to know the difference between a felony DWI and a misdemeanor DWI and how that was going to affect the client. And I realized that criminal defense attorneys, I think, you know, we think about things in terms of felony versus a misdemeanor. We have to stop doing that within the context of immigration proceedings. And I hear this a lot from criminal defense attorneys. I think it was kind of a shorthand way to think about immigration consequences, which was felonies are bad, misdemeanors are not bad. But the reality is that it's much more nuanced and complicated than that. And so felonies are not always going to result in deportation, and misdemeanors are not always going to be safe for your client. Instead, I think it's more helpful to think about things in terms of your client's current status and to start from that point. And so these are 6 kind of ways that I've kind of delineated the different statuses for you to think about. There's entry without inspection, which is someone who comes into the United States at a place that is not designated as a port of entry, right? So that could be somebody who crosses the river, who walks through the desert. It could be someone who did come at a port of entry, but who was not presenting themselves for inspection. So someone who was smuggled in the back of a car or something like that. That is an entry without inspection, or for shorthand, we call those folks entries EWI. There's a wave through, which is when somebody comes to the port of entry and they may have documents, they may have fake documents, or they may not have documents at all. But for whatever reason, they never present the documents and they're just waved through the port of entry by the immigration official. And this used to happen a lot before 2010. And with your clients who came as children, this may have been how they came. A lot of younger kids were waved through the ports of entry during like high crossing times, like Halloween or Christmas or something like that. A lot of kids were waved through. The third way is a visa overstay. So someone came in with a visa and then didn't leave during the time that they were supposed to. Your client could have valid visa status. And I say valid visa status, that's not legally entirely correct, but I think it's a good way to look at it. That just means that they have a visa that allowed them to come to the United States and that their status is still current on that visa. So it could be a tourist visa, a work visa, a student visa. They could have their LPR status, or they could be a DACA recipient. And so I think the first place to start is ascertaining where your client fits into one of these boxes, and then to go from there. So I'm going to start with the easy ones first. Well, before we get there. The reason that these are important, I think an important way to look at this is because it allows you to look at things with what does your client have to lose and what does your client have to gain. People who have entered without inspection are a wave through or a visa overstay. These are all the ways that they entered, but all of these people who fit into these boxes are undocumented. And because they're undocumented or because they don't have current permission to be in the United States, they are all subject to removal proceedings, regardless of the DWI conviction, regardless of anything else that happens. And under the Trump administration, if they are encountered by immigration officials, they will absolutely be placed into deportation proceedings. And that has to be something that's communicated to clients. What we're concerned about with these folks is not making anything worse, right? In terms of making them deportable for another reason or making it more difficult for them to obtain a bond. And we also really want to make sure that we're not messing up their eligibility to apply for relief from deportation. Folks who have status, valid status to be here, such as with a visa, LPR status, or have a DACA quasi status, what we're more concerned about is making sure that none of those statuses get revoked or lost, right? And to make sure that we're advising them about the effect that a DWI might have on applying for future benefits, right? And this is particularly important for DACA recipients, which we'll talk about. So advising undocumented clients is much more complicated. Advising these folks who have status is less complicated. So let's start with. So if you have a valid visa, and I'm going to explain this. I keep saying valid visa because it's simpler. This is what I mean. A visa is a piece of paper that allows you to come to the border. Okay, it doesn't actually give you status in the United States. So a lot of times I'll get requests from clients that'll say, I have a valid visa. My visa is good for 10 years, right? And tourist visas are given out on a 10-year period. That doesn't mean that once you enter, you can stay here for 10 years. It just means that that visa gives you permission to go to the border and request admission for 10 years. Once you get to the border, the officer looks at your visa and then decides whether to let you in. If they let you in on tourist status, that status is only good for 6 months. Okay, so that's something really important to remember. Tourist status is only 6 months unless they ask for an extension. So when I talk about a valid visa status, I just mean that they have some sort of non-immigrant status in the United States. They came with a work visa, student visa, tourist visa, and it has not expired yet. So if they get a DWI and they're in current status, it's not a violation of their non-immigrant status per se. Once they leave the United States and they try to come back, the FAM, the Field Adjudicators Manual, advises officers that their visa may be revoked for even an arrest for driving under the influence, which is in the last 5 years. But it is that risk certainly goes up with a conviction. So if your person is in valid status, you can tell them that once they leave the United States and try to come back on their visa, they may have some difficulties. DACA folks, people who are in current DACA status, will absolutely be affected by a DWI. Their DACA will be revoked. And they will also be barred from renewing their DACA status in the future. Now, the Santa Fe Dreamers is exceptional at applying for folks who have like 1 or 2 DWIs and they show rehabilitation. And I think they've had some success at getting folks DACA status. But we don't want to rely on the, wonderful talents of just a few attorneys. Your clients need to be advised that a DWI will revoke their DACA status. Additionally, 2 or more DWI convictions will presumptively bar good moral character, and that's going to affect their eligibility for relief. And if your DACA person has their DACA revoked, they are going to be deportable, and they're going to be put into deportation proceedings, and they will have to apply for relief. And we'll talk about that in a second. For a lawful permanent resident, 2 convictions for DWI create the presumption against good moral character, but the effect of that is that it just kind of makes getting naturalization or applying for naturalization more difficult for them, and they may have to wait for a certain period of time before they can apply again. Additionally, you cannot naturalize when you're currently on probation. The one I would also say to watch out for LPRs who have a lot of DWIs and they start getting into felony territory is that you really want to watch out for aggregating 5 years of confinement due to several convictions. That's going to create issues if they leave the United States and try to come back. So those are things to watch out for. Let's move to the hard stuff.
I have a quick question about just in backing up the LPR stuff. Would that, like, so how you said the confinement can be aggregated, would that happen for probation too? Is there, okay.
That's a great question. So normally when we talk about sentences and things like that, in the context of immigration, suspended sentences count as a sentence, right? This is one scenario where it doesn't. So what this ground of inadmissibility is really concerned about is an aggregate time the person spent inside jail of 5 years. And it could be related to as many convictions as they have. So like I said, once they start getting up into, a DWI, what is that, a 4th, I think is a felony, right? And 5th, and you have all those mandatory sentences, you just really want to worry about keeping the aggregate time that they're actually serving in jail to under 5 years. If you can't, it's not the end of the world, but you're going to have to advise your client that they can't leave the United States and try to come back, because that's the moment that this problem is triggered. Okay, let's talk about undocumented people subject to removal proceedings and how DWI affects them. So these are the 4 boxes that I'm using to talk about quote unquote undocumented people, right? People who enter without inspection, people who are waved through, people who overstay their visa, and people who have DACA. And the reason I've included DACA, folks, is because technically DACA is not a permanent status, right? It's a quasi status that protects them from the enforcement of immigration laws. But folks who have DACA are still technically undocumented because they don't have a permanent status in the United States, and their DACA status can be revoked for very, very minuscule reasons. So when we're talking about undocumented people, we want to get back to this. We need to advise them about whether or not they will be picked up by ICE because they're subject to removal proceedings, how that will affect bond, how that will affect relief, and how that will affect eligibility for future immigration benefits. So the first thing that you can advise your undocumented clients is that no matter what you do, unless they have current DACA, they are subject to removal proceedings. Actually, even DACA folks under the Trump administration are being placed into removal proceedings. So no matter what you do, there is a high risk under the Trump administration that they may be placed into removal proceedings. That risk goes up if they are convicted of anything, because if they have to report to probation, the risk is higher that ICE might be there waiting for them. So that's the first thing. Let me actually go to my next slide. However, because DWI is not a crime involving moral turpitude, it is not going to make somebody removable for any additional reasons other than they're here without status. And here I've provided the specific statutory citations that talk about, you know, people being here without permission or people who have entered in, you know, not at a designated port of entry, et cetera. So that's the good news. DWI does not make you removable. However, for the purposes of bond proceedings, a DWI can have a significant effect. And it's for the reasons that we were talking about earlier with that case from 2018. The DWI is a significant adverse factor against bond. So the way that bond works in immigration proceedings is the burden is on the applicant to prove that they are not a danger or a flight risk to the immigration judge. And immigration judges, particularly in El Paso and in Otero County, they consider DWI to be a significant factor against releasing somebody because they are a danger to the community. Now, that is not something that that is something that can be overcome, but you have to have a strategy. And so if your client is undocumented and they're about to plead to a DWI, the first thing that I would advise them to do, if they can, not everybody can, but would be to try to get an immigration attorney to start working with them and to start strategizing about how they're going to get a bond before they ever plead to the DWI. And that's
question.
Sure.
The question is, does this apply to people who have a previous deportation?
No. No, it does not. So the simple answer to folks who have a prior deportation, that they don't even get to go into removal proceedings. If you have a valid prior order of deportation, you don't get to see an immigration judge. All that ICE has to do is confirm that it's still you, and then they will reinstate the prior deportation order without any significant process. So none of this applies. So your job is easier in advising them, but the outcome is worse. So if you're wanting to prepare your client to get out on a bond when they have a DWI, as immigration attorneys, what we're concerned about is mitigation evidence or rehabilitation evidence. And the way that we kind of determine which one we're going to provide does this look like a lapse in judgment, right? Or does this look like this person has a problem drinking? And then you kind of decide where you're going to go from there. And that's, you know, that's a judgment that I think we all can kind of see with our clients, you know, have a bunch of arrests for, you know, disorderly conduct and minor in possession and open container and all these things. You know, you start thinking this isn't a momentary lapse in judgment. This person might actually have a problem with alcohol. Is there a question?
We did have a comment that about the previous question, and this is helpful if they don't reinstate, right?
Yes, it is helpful if they don't reinstate. That's a really complicated area of law about whether or not they're going to reinstate or not. So I'm going to move forward, but I just want to make it clear that when a client is pleading to a DWI, the sooner that the client can start putting together mitigation or rehabilitation evidence, the better. Because at the point that they are finally convicted, you know, plead guilty and are sentenced to DWI, they might get picked up by ICE. And so if they haven't had the opportunity to do the DWI school, the 12-step program that they get ordered to do and all of the other things, they may not have any evidence of rehabilitation to provide to the immigration judge in order to get a bond. So the sooner the client can start doing those things. In terms of how DWI affects relief for deportation for undocumented clients, I kind of just wanted to show the way my mind works and other immigration lawyers work, the kind of the triggering information that tells us what type of relief that a person might qualify for. And what we're really looking at is how long they've been in the US, the status of their family members, usually their spouse, their children, or their parents, and whether or not they've been a victim of certain types of criminal activity within the United States or in their home country. And that will really tell us what to screen for in terms of relief. I wanted to show you this because these are the types of kind of relief that we screen for. And these are the forms of relief that are affected by DWI. So I say this not to scare you, but to point out that advising on relief in DWI is usually the more complicated and significant part of the advice and counsel process when you're doing your immigration advice. Just to kind of, let me see how much time I have left. Okay, we have 15 minutes. So to kind of get into the nitty gritty here of why these are affected. So we talked about DACA, right? DACA is affected in a very straightforward way. If you have a DWI, you don't qualify for DACA. So if your kid, I say kid, now DACA folks are adults. If your client has DACA, or most importantly, may qualify for DACA and didn't have it before, because we hope that there will be new DACA applications under the Biden administration, one DWI will absolutely affect them and their ability to apply for DACA. In terms of cancellation of removal of a non-lawful permanent resident, this is a very, very common form of relief that most long-term immigrants have some kind of prima facie eligibility for. And what is required for cancellation of removal, is that they've been here for 10 years. They don't have a conviction for an aggravated felony. They have a US citizen or lawful permanent resident, spouse, parent, or child that would suffer exceptional and extremely unusual hardship. And number 4, and most importantly for our purposes, has been a person of good moral character for the 10 years that they've been in the United States. As we talked about, if you have a conviction for 2 DWIs, there's a presumption against good moral character. So that doesn't mean you shouldn't advise your client who's facing their first DWI that it's no big deal, right? You should, and you should tell them this. When you get to immigration, you're gonna have to apply for relief. And if you get 2 of these, you're probably not gonna be eligible for this form of relief. So we're halfway to a bad situation. Additionally, even having 1 conviction for a DWI can affect the way that an immigration judge applies discretion in your client's case. Okay, that's harder to advise on because it's super subjective, but even 1 DWI will have an impact. 2 DWIs will absolutely have an impact. Voluntary departure is the same. There are 2 types of voluntary departure. The first type is not affected by a DWI. The second one is. That's all I'm going to say about that. VAWA stands for Violence Against Women Act, and that is a form of relief that is available to immigrants who are abused or subject to extreme cruelty by a US citizen or lawful permanent resident, parent, child, or spouse. But for the purposes of VAWA self-petition, you have to show that you've been a person of good moral character. So we get into that same problem with 2 DWIs. And then finally, I highlighted asylum here. Like I said, I don't think that proposed rule will actually go into effect under the Biden administration. But just to be safe for the meantime, I think that we need to be advising folks who want to ask for asylum that they may be statutorily barred from asylum if they are convicted of a DWI offense. So that seems very complicated, and it's become more complicated in the last few years. So the question is, how do you advise your client without being an expert in everything? And the answer is that there is help. There are lots of great immigration lawyers in the state of New Mexico that are helpful and willing to help you with these types of questions. Many of my colleagues will provide 5 or 10 minute free conversations with any criminal defense attorney that calls them. And if there's a simple answer, they'll just provide it to you over the phone. If you are representing an indigent client through the Office of the Public Defender or through one of their contracts, then you have access to free crimmigration advice. I currently have that contract. If we start getting a lot more of these requests regarding DWI, we're going to be hopefully expanding that contract to another practitioner to provide DWI specific memos. That hopefully will be helpful. In the meantime, one of the things that I'm working on with the Public Defender's Office is putting together a memo that will help you to self-advise, right? Like a kind of comprehensive memo that I hope will allow the vast majority of criminal defense attorneys to get some input information from their clients and then apply it to this memo and then provide the information without having to go to an outside source. I haven't put that memo together yet because we're still working through the contract with the Public Defender's Office to get it done. But when it is posted, it will be here on my website, milesimmigrationlaw.com/DWI. One caveat to that is if you do use that memo, part of the reason I'm going to house it on my website is because DWI law changes so much that I'm going to be updating it as things change. So if you download it one time, don't just continue to use the same version. Always go back to the website and see if there's a new updated version of the memo, depending on what the law has done. To be able to use that information and to be able to accurately advise your client, these are the pieces of information that you need at a minimum. When you're requesting a memo from me, there's a questionnaire that we use online that asks this information and some other information. But at a minimum, if you're going to self-advise or ask an immigration attorney who's your friend or who's a colleague to help you advise, these are the pieces of information that you will need from your client.
We did have a question, Jessica.
Sure.
The question is what to do about a client who takes voluntary departure and leaves US before completion of DWI case, probation, etc., and leaves the US before completing probation.
I don't know. That seems like a criminal procedure question that I don't know the answer to. From an immigration standpoint, I mean, you obviously don't want them to have a violation on this side and then have the case, I guess, reopened or have something pending in case in the future they want to come back on a visa petition or something like that. But I don't know what the answer would be to avoid that on the criminal side.
Now I have my own question. So in advising a criminal defense attorney, what kind of information do you need about, say, the possible crimes that they can plead to? I mean, to what extent do you get into that? I like earlier, I love how you showed, plead to subsection 1 or 3 and not 2, right? Is that the kind of advice that you're able to give, or?
So yes, that's a great question, actually. What is most helpful? What is most helpful to me when asking for this advice is to tell me what you think the DA would be willing to offer, right? Because otherwise, like I said, my husband's a public defender, and we always say that I think that he's a wizard and he can do impossible things, and he thinks that I'm a wizard and I can do impossible things. So it's helpful for you to give me an idea of what you think might be possible, and then ask, would this be helpful, right? And then I can kind of analyze that. Otherwise, what I end up having to do is look at the police report on my own and try to think about, well, gosh, what do these facts support? And go through the statutes right next to it and look and see, what do I think might be a statute that could be pled to, and then do the analysis. So as much alternative plea information as you can provide is helpful.
Any other questions? I'm here on the chat. One comment that I wanted to make, I was a former public defender myself, and I got into a sticky situation with a client who was a Norwegian immigrant and had been here since he was about 5. So none of the alarm bells went off in my head to inquire about immigration status, and it ended up being an issue for me and my client. So I think it's important to consider inquiring about immigration status no matter what. There's definitely indicators that will lead that at that time when I was practicing that led me to inquire about immigration status. But I think it's important to always ask, right? So just my 2 cents there.
Yeah, I completely agree. I think, the first 2 questions that you ask when you're at arraignment are what's your name and what's your date of birth. You need to automatically ask a 3rd question, which is when were you born? Right? Don't even ask what your citizenship is, because I feel like, that's like a follow-up question, right? But I think if you ask where the person was born, that's a really easy way to ask that question that can kind of lead. And if they're like, well, I don't know, and I was here, and then it kind of gives you that red flag to investigate a little bit more. But where were you born should be a question that we ask every single person that we see, because not all immigrants speak Spanish, right? Not all immigrants are Latino. Not all immigrants are, whatever we think of or we see on the news. Patrick is absolutely right. Lots and lots of non-citizens live among us, and we need to make sure that we're giving them the best advice that we can.
So, Jessica, I also had a question following up on that. We often get clients coming in saying, I'm going through this. My criminal defense attorney told me that I had to seek an immigration attorney to advise me on the consequences of my particular plea and everything else. And obviously, we always reach out to the criminal defense attorney and say, okay, here's the stuff that you need to be aware of. But I've seen it in the past and even had to file some motions to vacate based on Pereira, based on that the defense attorney represented to the court that they advised on the collateral consequences because the client went and spoke with somebody. And sometimes that somebody is a notario público or somebody that helps fill out immigration forms. Can you talk about sort of the responsibility of the responsibility to advise the client and the criminal defense attorney being that person?
Absolutely. And we are going to have a 2-part series specifically for this reason, but the state of the law, both federally and state law, are absolutely clear, okay? The burden is on the defense attorney to advise. It is not on the client to find an immigration lawyer. It is not on an immigration lawyer to advise the client. The duty to advise is on the criminal defense attorney. And so the way that we structure that in New Mexico is that the criminal defense attorney reaches out to the immigration lawyer, and the immigration lawyer provides the information necessary for the criminal defense attorney to advise, right? When I do the memos, I don't even talk to the client. I provide specific advice to a criminal defense attorney that they can use to educate themselves, become competent on that particular case, and then provide the accurate advice. And then they can come back to me to ask any follow-up questions. The other thing that's important is if your client is indigent, it is absolutely not their burden to pay for an immigration attorney to advise, right? Like that is part of your client's right to a government attorney, representation at the expense of the government. And so I can tell you New Mexico does a fantastic job of making sure that this is provided. That doesn't exist in El Paso at all. It's like super ad hoc. And so if your client, and I would say as an immigration lawyer, I've definitely had to reach out to the criminal defense attorney and say, this is not like really the way it's supposed to work. You know, how can I help you get through this case, but how can we set up a process in the future to make sure that you can meet your obligations, right? So you're not getting an ineffective assistance of counsel charge later. but also so that we can make sure that the clients are being taken care of.
Okay, I think we're probably going to have to wrap it up. Jesse, I'll ask you if you're willing to stay for a bit. Looks like we have at least one more question, but I want to just let everyone know that we're out of time. So thank you for attending, and you're welcome to stay for a couple of questions. If you would like to receive CLE credit and did not receive the form, email Cheryl Burbank to receive the form, and we have taken attendance so we can confirm whether you were here. And thank you so much for everyone for attending. We do have further CLEs planned, as Jesse mentioned. We'll be distributing information about those to you, and we hope that you can continue attending these, and we really welcome your questions and feedback. And so thank you very much for attending, and I think we can stop the recording and proceed with some more questions, for those of you who'd like to stay. Looked like Zoila had a question.
Oh, no, I was clapping.
Oh, okay, clapping.
I was saying, because it's true. I think a lot of times people just try to pass the buck of saying, go ahead and consult an immigration attorney to sort of avoid the malpractice issue. But access to an immigration attorney can actually be expensive. It can be a process. Some attorneys charge a consultation fee. And so in that regard, I'm glad that you sort of, because if the client went back and said, well, the immigration attorney said it's actually your job, I feel like it's not very responsive. And so the fact that you're like, what do you need from me to make sure that you are comfortable given this information, and we build your capacity so that you sort of own it. And I think that that's crucial. So thank you for doing that.
Thank you, Zoila.
Any other questions? I don't. Go ahead, Jesse.
Yeah, if any other questions come up, the best way to reach me is probably through email. If it's an urgent question, well, I guess let me put it this way. If you're a contract attorney and you're providing indigent defense, go through the process. And you can go onto my website at www.milesimmigrationlaw.com/LOPD, and it'll give you the steps to the process to request an immigration memorandum, right? And it's like an automated process that hopefully, kind of streamlines everything. I will tell you that depending on how many requests I have, sometimes I get behind. So if you have a deadline that's really urgent, email me and tell me exactly what your deadline is, and I will bump you up to the top of the list and make sure to get you what you need at the time that you need it. So if you're providing indigent defense, that's the way to go through this. If you're not, if you're a private attorney that has been hired and you have some questions, feel free to email me. If it's a quick question, I'll give you a quick answer. If you want something more formal, like a memo, which is honestly what I suggest in order to cover yourself and have in the file, then we can talk about the process for that. And like I said, there's other immigration attorneys in New Mexico that are also willing and able and great at providing that as a paid thing. Thank you guys for coming. Feel free to email.
Thank you, everyone.